eventually into first-party claims. I even spent some time when I first moved to Colorado many years ago selling roofs. So I've been up on roofs, I've looked at hail and wind damage, I've met adjusters, I've got into arm wrestling matches with them up on roofs. And then I got my license in Colorado and started advocating for policyholders instead of arm wrestling adjusters on roofs. So up until about a week ago, I wasn't really sure what my presentation was going to be. I'd been fighting a lot of things recently revolving around appraisal. So I thought I might talk about appraisal. And at previous conferences here, PPA and Win the Storm and some other places, lots of folks have presented about documenting the file and why that's so important. I was going to present on that. And just last week I kind of pivoted because I had a file that didn't have a proof of loss in it yet. And so Cal sort of teed me up right before this to give my talk on what is all the fuss about on the proof of loss. So thank you very much, Cal, Sean, for having me come and present. So it probably won't surprise those of you in this room that most policyholders have no idea what their duties after the loss are. Just like most people in the general public have no idea what a public adjuster even is, right? No one knows. Before I started doing this kind of work, I had no idea that there's this long list of things that I really ought to be doing for myself as a policyholder to now put the insurance carrier under the gun for paying my loss. And so it's our jobs as advocates, attorneys, PAs, contractors, to make sure that we're putting the policyholder in the best position to recover for their claims. So, looking at the forums, you know, we've got a bunch of different forums out there. Someone asked a question, it might have been Cal a couple of months ago, on what do you all view, you all generally, not just in this room, but just the advocates in general. What do you think your role is? What's your job as a public adjuster? What's your job as a contractor? For contractors, it's a lot more straightforward, isn't it? Our job is to hopefully, eventually do the work, right? But up to that point, what is it? Well, we got to assess the damage on the property. We got to look at the property, figure out what's wrong with it, develop what the proper repair methodologies are to repair the property, and then what the costs are associated with that. PAs, you sort of get to do the same thing, right? Especially if a contractor isn't involved yet. And then taking the next step. Your license allows you to take the ball and take the next step with advocating for the policyholders, and that is helping them with some of these duties after loss. In the forums, and I'm sure many of you saw this, a lot of the PAs were like, well, my job is to argue the policy. My job is to fight with the carrier to get coverage. My job is to get the policyholder every cent that they're owed. Well, yes, but how do you get to that? How do you do that? And as Cal just spoke about, the first thing is checking off those duties after loss for the policyholders, getting all those ducks in a row so that you're now in the best position, you, the policyholder, are now in the best position to present the claim to the carrier for indemnification. So this didn't necessarily come up in that conversation in the forums, but something that I come across frequently because before I started shifting my practice to first-party insurance claim disputes. I did and still do a lot of work for contractors, and I arm wrestle with them quite a lot over contingency agreements. We'll do the job for whatever your insurance company's going to pay. And that doesn't really do the policyholder any good in terms of satisfying any of their duties after the loss. If you don't give them a number, they have nothing to present to a carrier to say, this is what you owe me. And I get it. For the contractors, the psychology of the sale, right? It's easier for me to get the homeowner to sign the dotted line when I'm telling them, all you owe is your deductible, and we can work out what the total cost is going to be later when your insurance company comes out. I get it. That's how many of the storm chaser business models are set up. Contingency agreement, we'll do it for what the carrier is going to pay. But that doesn't help the PA or the lawyer down the line that is now going to have to prove up the loss. So let's talk about the duties after loss. Cal, again, he teed me up really nice on this. Over on the left-hand side, these are typical duties in most policies, right? Promptly give notice to the carrier. Almost everyone gets that. We have a loss, we call in the claim. Boom, we've notified the carrier. That one's easy. Everyone gets that. Protect the property from further loss. This is a case-by-case analysis, right? If it's a hailstorm, do you have any leaks that are coming in right now? Did wind blow shingles off the roof where now you got to tarp it and protect from any future storms that might be happening over the next couple of weeks or months while the claim is being resolved? Have a contractor get up there and do that. And if they aren't charging right now for it, if they're going to roll that in for whatever the insurance company is going to pay on the claim, have them document it, roll it in. We made temporary repairs on X date. If we were charging you, this is what it would be, and so you can expect to see this in the final invoices. Identify damaged versus undamaged property. So Cliff this morning had a really great presentation on concurrent causation and how this is one of the duties. You've got to do this. And so don't hide from old damage. Point it out, there it is, but we're not talking about that. We're talking about this damage from this event and the problems that are associated with that. Be prepared to submit documents and records. Again, this is all stuff for the policyholder that oftentimes a PA can help with, and contractors. The big piece that you're helping out with as far as the duties after loss go, oftentimes you're helping them call in the claim, but the value of what the repairs are going to cost. You're often the first people out there, and that component, the value of the repairs, the legitimate, reasonable, and proper repairs, is coming from you. Allow the carriers to inspect the damage. We all do that, right? The carrier wants to send out their adjusters to come take a look. Do it. Needs to be done. Be prepared to submit to an examination under oath. I don't see that often, but it happens from time to time. So PAs, I'm sure that when you're going through a policy with your policyholders at when in your first couple of meetings, you're pointing this out. It doesn't happen often, but it's something for them to be aware of. And then the one that almost always gets forgotten is the proof of loss. Now this group, we're all educated, we come to conferences like this, and we're aware of it. So many of you are getting this done, and that's awesome. because it is super important. On the right, I've got two examples there of duties after loss sections specific to proof of loss. So on the first one on the left there, you must submit a proof of loss within 60 days after the loss. And in this particular instance, it must be sworn. On the right, send us your proof of loss within 60 days after we request it. Well, isn't that clever? We don't want you sending us anything until we ask you to send it. And the secret is because they're not on a clock until you submit the proof of loss. So they don't ask you for it. 6 months down the road, you take the file to a lawyer. All right, we're ready to go forward with this. Did you get the proof of loss submitted? No, hell no, they didn't ask for it. Well, now I become a very expensive public adjuster because now I'm working on getting these documents submitted to prove up the loss. And so I've seen this in the forums too. Exactly that. Well, we don't have to send it to them until they ask because the policy says we don't have to send it to them until they ask. That's right, there it is. Black and white and highlighter yellow. Not until we ask for it. But there's a problem. Here's some cases, and these are some samples of some recent case, recent citations that have come up just in some files that I've worked. Trial court properly granted the insurer's motion for summary judgment where the insured failed to file a written proof of loss within 60 days after the loss. That's going to be similar throughout these other cases. Now in Michigan in particular, and a lot of places, all right, the case law has developed where maybe you can get by on this if the carrier can't prove that they were prejudiced in some way. Except in Michigan there, doesn't matter if they were prejudiced or not. If you did not submit the proof of loss, game over. You're done. So I co-counseled on a case in Michigan not too long ago. And we had really good bad faith evidence, okay? Things were looking really good for us. We got their experts' testimony and report excluded, not because we did anything that was particularly effective in the litigation, but the other side kept missing discovery deadlines in the litigation. They didn't get us their expert report in time, even after they got several extensions. Anyway, we got that excluded. We got their adjusters in deposition talking about what their report and their claim note said on, this was a Ludowici tile roof. Well, how'd you come up with this? You said 10 hail hits per slope. How'd you come up with that? Do you have a map of the roof where you marked those 10? We got them to essentially say, well, we just made that number up, right? So we're looking really good on the quote-unquote bad faith stuff. Now, Michigan doesn't have an Unfair Claims Settlement Practices Act, so that's for another talk, and why most lawyers are not good lawyers in Michigan because we just have no leverage up there. But all these things were going for us, and in the end, we lost on summary judgment because before I ever got involved, I got involved maybe 9 months after the loss occurred, but the policyholder nor the contractor knew anything about the duty to provide a proof of loss. The judge went through an analysis of, well, there really wasn't any prejudice here. The policyholder had every opportunity available to them to get the proof of loss submitted. The contractor had provided an estimate like 120 days after the loss occurred, and then that's when the policyholder filed the claim, but they never got the proof of loss done. Summary judgment in favor of the carrier, into the case, done deal. Montana, such a condition in the policy is a condition precedent, and failure to comply with it bars recovery. So these are all just examples of no proof of loss in time, you're done. But savings graces here. So here's a list of case quotes where, all right, maybe you don't get the formal proof of loss submitted in time. You might still have some wiggle room, but this is state specific, guys. This depends on, you'll notice I don't have any savings graces on, except one for Michigan again. Were the documents that you provide a functional equivalent or in substantial compliance with the proof of loss requirement? And then again, there's I don't have it up here, but many jurisdictions will talk about, and this falls within the realm of late notice. So maybe you get a late proof of loss packet submitted, and the argument is that's okay so long as the carrier is not prejudiced by the late notice. So substantial compliance, functional equivalent, sufficient if it gives the company enough information to enable it to frame an intelligent estimate of its rights and liabilities. And that's the spirit of what these sort of exceptions to the requirement are. Are you giving them enough information so that they can make an educated decision on what their liability is under the policy? But notice this one second to the bottom, this Idaho case. It must also mention a specific sum so that a tender can be made by the carrier. You got to tell them how much they owe you. That is one of your duties. It's not their job. Cal talks about this a lot in the forums, in the boot camp. How ridiculous is it that they've convinced, the insurance carriers, have convinced our population in general that it's their job to come and tell you how much they think they owe you, right? That's how most people believe the claim system works. I had a loss, I file a claim, insurance company is going to come tell me how much they owe. It's rigged. I mean, it's what's the saying about the greatest fraud on humanity that the devil ever pulled was convincing us that he doesn't exist, right? I view this much the same way. It is rigged when everyone believes that the insurance company is going to come tell us how much they owe us. So here are some of the traps on relying on some of these get-out-of-jail-free card exceptions when you're trying to say, well, we gave them an estimate 6 months ago, and that should really satisfy the proof of loss requirement. In order to get over the prejudice hurdle, you got to be sure you've tightened up the ship and you've satisfied those other duties. And that this is the one that you kind of let slide a little bit. You got to prove that the carrier wasn't prejudiced with your late filing of a proof of loss or your other documents as the functional equivalent or substantial compliance. And then here's the thing about why you really don't want to even let that happen. Is all these cases that talk about the get out of jail free card, the functional equivalent, or the substantial compliance, is you don't get to decide what that is. Neither does the carrier. Neither do I as a lawyer. The only people that get to decide if what you submitted satisfies this exception is a judge or jury. And you know when that happens? A year from now, 2 years from now, when you go to trial. Otherwise, that's going to be a question that's left open during the litigation the whole time. And our ability as lawyers to twist the carrier's arm on potentially settling as soon as possible is left open when this is a question. Was that roofing estimate that was submitted 120 days after the loss, did that serve as a functional equivalent? Maybe, if it was just kind of your vanilla wind or hail shingle claim. Now, does that satisfy it if it was a tornado claim and the roof is torn off and the only thing you've got submitted at that point is the roofing estimate? What about all the interior damage? What about all the contents? What about electrical that now needs to be redone? What about this? What about that? So it's all a fact question that ultimately has to get decided by a judge or jury. So why leave that open to question? The best practice is don't leave it open for question. Get a proof of loss submitted as soon as possible, as soon as you have enough information to make you comfortable that you have justified the loss, the repair methodologies, and the cost to do the work properly. Get it done. Call it a proof of loss, even if it's just your letter. So there was a question in Cal's talk earlier about, sometimes it says that they're going to send us a form in the policy. Don't wait. Don't wait. Get one of these generic proof of loss forms. Ask one of the lawyers. We've all got our forms. We change them, we tweak them based on developments in the case law that we're seeing. Get it done. Ooh, I got to get closer. Okay, so best practices for the proof of loss. You'll notice on the two excerpts that I shared a few slides ago, both of those required that it be sworn. They didn't say notarized, right? They just said sworn. There's a difference. The adjuster on the other side, when they get your packet and it's not notarized, they're going to tell you this needs to be sworn. Well, yeah, it is. See the language in there where the policyholder says, I swear that these are the damages that exist at my property and that this wasn't caused by any wrongdoing on my part. It's sworn to. Oh, no, it's not notarized. That policy doesn't require it to be notarized. Okay, so some of the basics to have in the packet, the proof of loss packet. The date and approximate time of day of the loss. The cause of loss. Was it a storm event, wildfire, hurricane, flood, front end loader on the golf course crashing into the house on accident? Whatever it is, list it. Changes to the use or occupancy of the property. So one that I'm seeing a lot recently is, well, gosh, with mortgage rates so high, we couldn't sell our house, but we ended up buying the new place already, and so we're renting the old place. But geez, we didn't let the insurance company know that it's a rental property now. Okay, But in the proof of loss, we're going to tell them that at the time of this loss, you had tenants in it, and that's how it was being used. We don't want to hide anything. You didn't inform them, and we'll deal with the problems that could potentially arise after that. But we want to be open and transparent. Listing all the parties with an interest. I think Phil and Cal kind of went back and forth on this, listing the mortgage company, right? Who's the most recent mortgage company? It may not be Quicken Loans like it was 5 years ago. Now it might be PNC or Truist or whoever the mortgage got assigned to. Inventory of the personal property that is claimed to be damaged. And then this is what a lot of our experts that have been up here presenting on are here to help us with. Support the proof of loss packet with a comprehensive set of documents. The estimate to do the job right. Not what some cheap corner-cutting contractor can do the work for. That's not what the policy owes for. The policy owes for the repair work to be done right. So estimate it to be done right. Include the manufacturer's specifications, guidelines, bulletins, installation instructions. Include the applicable building code requirements. Include the proper way to do the mitigation work under IICRC. Include that stuff and spell it out. So Candace talked about it in her talk. She loves those estimates that under each line item, you're referring to the justification that tells you why this line item is necessary. That should be referring to these things. And I love those estimates too. Every lawyer in the room loves those estimates. Tons of photos. That goes without saying, right? We want to take as many photos, high quality photos of the damage as possible to demonstrate to the desk adjuster 1,700 miles away that this is really a bad loss. And then include a narrative, for the public adjusters and contractors. My first inspection of the property was on such and such date, following such and such event. My observations were yada, 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 yada. These are the damages that I saw. Include that in the packet. Make that an introduction to the estimate. And then, so this is one that I see folks are scared of a lot of times in the forums is, well, particularly contractors, right? When they're putting together an estimate, what if I'm wrong? What if I find something else later on? Well, then caveat it. And you'll notice that many of the lawyers that attend this and that are in a lot of the same forums, we include a caveat. This is subject to change based on undiscovered conditions of the property, undiscovered damages, or new information that we may develop throughout either further investigation or throughout the repair process. We're going to find some stuff out that we have not yet contemplated, and we'll supplement these amounts based on that new information. So why is this important, the proof of loss? Well, for one, the policies require it, right? But the clever trick on until we ask you for it, you don't owe it to us until we ask you. Well, here's why that's nonsense. Because many of the statutes that are tied to when penalty interest starts, when attorney's fees can now be recovered, are all tied to when a proof of loss gets submitted. And so if a carrier is telling you, you know what, they don't tell you we don't need it. They just don't say anything about it. And then oftentimes, a savvy public adjuster, I'll get this question from time to time, hey Travis, man, we sent in our proof of loss and the carrier said that they don't want it, they don't accept it. I don't care, you sent it. They're telling you they don't accept it because they don't want to be on the clock yet. But unless there's something technically deficient about it, their desire that it's on their desk or not is irrelevant. Okay, so Texas. Notice of acceptance or rejection of the claim. They've got to do that within 15 days of receiving the proof of loss. Okay, again, well, we send in an estimate. We don't get to lock them in on that date unless it's a proof of loss, a formal proof of loss. Now, we can argue at trial later to a jury that estimate from a year and a half ago, that was effectively a proof of loss, and that's when interest and the time clock should have started. But we'd rather not do that. We'd rather not have that be a question when we're fighting about all the other stuff, right? Let's just eliminate this one as a variable. Colorado. So Colorado's interesting. You see here, they don't use in their statute, they don't use the term proof of loss. They talk about a valid and complete claim. And then they've got this long laundry list of what that means. But on number 3, that the terms and conditions of the policy have been complied with by the insured. And the policy requires a proof of loss. So get it done. Get it to them. Put them on the clock. Washington, same thing. Within 15 days of submitting an executed proof of loss. So Washington is interesting. Some of their cases talk about, well, the statute doesn't really tell us what a proof of loss means. And it doesn't really say that there's a particular form that it needs to be. And the statute really doesn't say that it needs to be sworn or notarized. And so these were in cases where the carrier was essentially trying to argue that the substantial compliance packet that was submitted failed because of these other things. And anyway, that's just sort of an interesting, for me as a lawyer, among the cases that I was reading. For you guys, doesn't matter. Proof of loss, call it a proof of loss, submit it with all the supporting documents. End of story, and put that behind you. Similarly, Idaho here. So Idaho, attorneys like Texas, if a carrier misses some of those deadlines, so 30 days after proof of loss has been submitted and they haven't made a decision on the claim and paid it, penalty interest starts and attorney's fees are now on the table. So I mentioned that Idaho, like Texas, because we lawyers can be way better lawyers in states like that with prompt payment statutes, because attorney's fees are recoverable even if the carrier is doing everything else right. They aren't violating the unfair claim settlement statutes. They're just late. If they're late, they owe interest and attorney's fees. That's it. In many of the other states, it's not quite that easy. You've got to have the evidence of Unfair Claims Settlement Act violations to now be able to recover attorney's fees in many instances. Or in some states where there is a statutory breach of contract attorney's fees recovery. But that's not everywhere. It's dependent on the state. And many states follow what's referred to as the American rule, which is attorney's fees are not recoverable unless the contract itself says it, or there is a statute that provides for it. And the statute related to what we all do are those unfair claims settlement practices statutes that say, carrier, if you screw up one of these 14 to 17 things, then you're going to owe the policyholder's attorney's fee. But Idaho and Texas make it simpler. You miss a deadline to pay, you owe attorney's fees. Montana, notice there is no prompt payment, and therefore you get attorney's fees, but penalty interest starts following proof of loss submittal. So what's next after the proof of loss? And this is probably not what's next, but what is also involved. So contractors build out a comprehensive estimate that does the job right. So I emphasize this because many of the cases that are on my desk right now deal with appraisal. And usually it is an insured's appraiser that has developed a comprehensive estimate that has manufacturer's guidelines built in, has code built in, has IICRC, has other stuff built in, all justifying it. Meanwhile, the carrier's appraiser's like, well, we can find Chuck in the truck to do it for. I know that there are contractors that aren't going to follow code. I know that there are contractors that are going to cut corners, and that's all that we really ought to pay for. We are hammering those folks with, well, if that's how you feel about it, then you're incompetent, and you might be biased. But that's all a fact question that you have to fight out in litigation. But my point is that from our perspective, and this really, let's be honest, the repair methodology in a vacuum should not change based on whether or not the adjuster or appraiser is working for the insured or the carrier. It should be the same. There may be minor differences over opinion on certain things, but overall, it should be this. And by that I mean, like, okay, the fence, does it need to be pressure washed and stained and clear coated? Or maybe it just needs to be pressure washed. Or pressure washed and stained, but not, those types of things. Not huge, significant manufacturer's installation guidelines things, not big code things. I saw a recent file where an umpire in an award said, my opinion is that the water that came in from the roof and ran down the walls through the insulation and got into the ceiling probably isn't category 3. Okay, what's that based on? Did you hire a mitigation expert to come in? Did you have anyone come in and test it, or you're just making that up? Well, the answer is they were just making it up, right? So another thing for contractors to do, inform the customers and the PAs and the attorneys, if applicable. Inform them of the best available information based on your experience. Again, contractors are experts at what they do. They may not be able to argue policy provisions and case law, but they can tell you what it's going to take to do that job right. So tell us, let us know what you really think, what your true opinion is on how this job needs to get repaired. And so the documentation stuff, this is kind of where contractors get to play ball also. And they'll see this a lot. They submit their estimate and they get the stuff like, oh, we don't pay for overhead and profit on a job like this. Or we're not going to pay for drip edge, or we're not going to pay for whatever. Well, contractors, again, steer clear of arguing about what the policy does and doesn't cover, and more on, well, you know that the manufacturer requires this, and now the building code, they require drip edge, and we had a mitigation contractor come in here, and he said that the IICRC is telling them that this, and so I've incorporated that into my estimate, and so you're really telling me that you don't cover that? Why? I mean, just let me know why, and I'll talk to my customer about that and what other options might be. But really what I want from that is to see what the carrier responds with. Are they going to correct course? Oh, yeah, you know what, you're right. The building code does require that, so that is probably the proper way for the repair to be done. Now, the question on whether or not they owe for it, that's a different question. So I'll pause for a second. That's an important distinction. How the repair should be done properly is different than does the policy, as it's written, actually cover all of that? Those are two different questions. One, the contractors get to tell us. Two, the PAs and lawyers get to fight with the carrier about. And these days, it's not as straightforward as it was. A lot of the times, a lot of the cases that you hear people talk about in the forums are based on language and policies that were a little unclear, little vague, little arbitrary. One of the lawyers earlier talked about the gray area that we kind of live in. That's where the arguments and the arm wrestling happens. Carriers are they are smart. Cal says this all the time. They are super smart. And they lose a bunch of these cases on those ambiguous terms and provisions and languages. And guess what? The next iteration of their policy, they include stuff in there now. And so a popular one these days, ordinance and law, right? Okay, used to be an open question and still is in many policies. But some policies now explicitly say we do not pay for the increased cost of repairs associated with ordinance and law. Now, lawyers are still winning those cases depending on the state, depending on the existing case law that supports the arguments in those cases. But many state courts will say, yep, parties are free to contract however they want to, and if that's what they agreed to, that's what they agreed to. And then we get to argue, oh, but there's the ordinance and law endorsement now that brings coverage back in for that, okay? But that's the lawyers and the PA's argument to make, not the contractors. So, I talk about the public adjuster, what can be done to help advocate for the policyholder after the proof of loss. And it's a lot of the same things that the contractor is doing, but now you add on the aspect of, we're going to talk about the policy provisions and what my learned mind as a licensed public adjuster tells me about your policy and the coverages. And then you see, I've got in writing up here, in writing, in writing, in writing. Adjuster calls you up, hey, you got time for a quick second to chat? No. Send it to me in an email. Whatever questions you got, whatever points you want to make to me, send it in an email, because if it's not in writing, it didn't happen. That's essentially the way that trial testimony works. You cannot testify to what anybody else says to you. You've heard Melanie talk about hearsay. There's a rule in evidence called the hearsay rule. I can't testify to what you told me. The best evidence for what you told me is you. We're going to get your ass on the stand and ask you these questions. And then you might lie about it. But that's all the jury's going to hear. So get it in writing. So what are the benefits of that? The hearsay, the he said, she said doesn't come in. Now, you can talk about that stuff in deposition, right? When someone asks you a question, well, what about this? What about that? You know, on the inspection, the carrier's adjuster told me that he wasn't going to write for that, even though it was obvious, because he knows that the desk adjuster is going to kick it back and tell him to remove it anyway. Okay. Well, at deposition, you can give that answer. It's not going to come in at trial, and you can tell us, the lawyers, that that happened, and that gives us direction on where our investigation needs to go. But those types of things, we lawyers hear all the time. Oh, I've got a great bad faith case because of this, and the adjuster said that. Doesn't matter. Is it in writing? What can we put in front of a judge or a jury? All right, okay, let me wrap this up real quick. Another couple of things for the benefits of having it in writing is you have an opportunity to get them to change course and do the right thing before it ever comes to us. Now, is that going to happen often? Probably not. Adjusters' egos are in play. I'm right. By golly, I'm right. I'm not changing my mind. It doesn't matter what you tell me, what you point out to me, how you justify it. I'm not changing my mind. But there's a shot. And now you give them an opportunity to double down on whatever the misrepresentation is. Now you've got something. And not only is it now you've got something, but now we get approved to a jury later on that they didn't just make a mistake the first time. You gave them a chance to do the right thing, and they chose to continue with the misconduct. And juries will give them the benefit of the doubt. One time, that was a mistake. 2 times, nope. So summary, best practice. Even if it's just your letter, your damage assessment with an estimate, write in bold black Sharpie at the top, proof of loss. Even better, have all those requirements that I had on the slide for best practices to include in the proof of loss, and the sworn to statement. We swear that we didn't do this shit to our own house, right? Okay? Revising it throughout the claim as new information is developed is okay. We just supplement it. But in a perfect world, we wouldn't leave any doubt about what we're demanding from the carrier to pay to indemnify the policyholder. And get them on those statutory clocks as soon as possible. Here's my contact information. Feel free to reach out with any questions. And Derek, we good?
Yeah, we're great.
Okay. All right.
You got time? You want to take one question, or you'll see if there's 1 or 2 questions, or?
Yeah, sure. Yeah. Yep.
Do you do a best practice to generate your own proof of loss and submit that to start the clock?
Yes. Yep. And then they can come back to you and say, well, that wasn't on our form. You get their form then. Well, is there anything on their form that I didn't actually include? Usually the answer is no. Sometimes it's yes. And what I see most often is the notary requirement. While it's on their form, the policy doesn't say that it must be notarized. It just says it must be on their form. And so then you kind of my recommendation in that instance is take their form, fill it out, submit all the same stuff with it, and just say, this is a supplement to the previous proof of loss that we already provided you on such and such date. Now, is that gonna win the day? I don't know, we'll have to fight about it. But referring back is better than just waiting. Yep.
You have a proof of loss turned in that has an error on it saying that a policy number is incorrect or the claim number, and it has to be reissued, and that takes 2 or 3 weeks. Does that reset the clock for the carrier? All the other pertinent information was correct?
I'd say most likely the issue of prejudice, the get out of jail freeze on prejudice comes into play. Did they have all the pertinent information related to the loss for them to make a decision on? So I'd say it may still be something we have to prove to a jury down the road, but in preliminary discussions before we get to trial, we would argue, no, this all relates back to that initial submission.
What if that 2 or 3 week delay in the time that you sent the first one that was erroneous, and the time you sent the corrected one, what if during that period of time, the 60 days passed?
Yeah, we're relating back to the initial, for sure. And we're making, and if it comes up, this is if it comes up, we're gonna argue you weren't prejudiced. You guys knew what claim this was for. You knew what the address was. You knew who the insureds were. You got the rest of the packet. You guys knew. So that, I mean, you raise a good point. And this happens quite a lot where a policyholder calls their agent. It's their golf buddy. They know him from church. It's their bowling league buddy. They're on the softball team together, whatever. And the agent tells, oh, you know what, that storm wasn't that bad. I wouldn't file that claim. Nuh-uh. Forget the agents. Get the policyholders to file the claim, period. Directly to the claims department, because the agent's going to try to talk them out of it again. Yep.
All right, thank you.
All right,
Let's have a round of
thanks.
applause.